All right, guys, welcome back to another edition of Lawyered Up. I'm your host, Jared Moore, and as you guys know, if you tune into the program, I am not a lawyer. On today's program, we have what is probably, I think everybody can agree, is the biggest decision that's ever come through the Supreme Court, maybe the biggest decision that's ever come out of the tribe in the history of the tribe. And that is the decision in the Grayson and Kennedy Freedmen case. And we're going to get into it in just a second. I wanted to mention to you guys that there are two links in the description of this video to some coverage that we've been following, like the Stroble case. With the Stroble case, if you guys want, can click that link and read that coverage. But in a nutshell, basically what the Oklahoma Supreme Court said is that McGirt doesn't apply to any civil laws or civil cases, and they're saying that Stroble's filing for back taxes under the Oklahoma tax regulations is a civil case, so McGirt doesn't apply. That's it in a nutshell. The other thing that is an update on coverage is the Muscogee Creek Nation has filed a lawsuit against the city of Henryetta about jurisdictional issues, and you can click the link and check that out. And I'm not going to go into either of those too much tonight just because we're going to be talking about this big decision. But what is the big decision? Well, I am going to pop this up right now, and we can just start going through it. So we are on the MCN Supreme Court's website, and let's go over here to opinions, and go down, and you'll see here we have Citizenship Board of the Muscogee Creek Nation versus Rhonda Grayson. Let's click through, and you'll see all of the stuff we've covered before here, guys. And then we finally have the order and opinion. Let me make it big so you guys can read it. And then the first thing I want to do, there are some things I want to point out in this decision that I think are interesting, but I'm going to go down and read the opinion and order first so that you guys know what they said. Excuse my throat. All right, here we go. Conclusion. For the reasons stated above, the court affirms the district court's September 27th, 2023 order and opinion on appeal from Citizenship Board of Muscogee Creek Nation denial of Creek Freedmen citizenship applications on grounds that the applicant acted contrary to law when it failed to apply Article 2 of the Treaty of 1866 and denied the respondents' applications for citizenship solely for failure to trace lineal descendant on the Creek by blood Dawes roll. Further, the court finds that any reference to, quote, by blood, end quote, citizenship in the 1979 Muscogee Creek Nation Constitution to be unlawful and void ab initio. The matter is remanded to the appellant Citizenship Board, who is directed to apply the Treaty of 1866 and issue citizenship to the respondents. Any other future applicant who is able to establish a lineal descent by the Creek by blood Dawes roll or the Creek Freedmen Dawes roll. So there you go, guys. That's a Freedmen win, and they are, according to the Supreme Court's decision here, supposed to be getting citizenship. Now, the things that I wanted to point out, well, first off, I don't know if I've mentioned it before on the program, but this phrase, void ab initio, I feel like I've explained that before. If you guys have a question about anything that I read that's like a legal term, let me know, and I will try to tell you. If I know what it is, I'll try to tell you. So what happens now? Well, first, I want to go up here to page 3 of this decision and read some stuff to you guys because I thought it was interesting. And I'm sure that you guys will find it interesting too. Where are we at? Page 9. This time I made sure to make a note of what pages are the stuff is on that I need to read because I know I do that all the time. I'll forget where it was. Page 3, here we go. So the section I'm reading from here is, let me go up a little bit here so you guys can see. It's the background, and then they talk about the Treaty of 1866. But what I thought was interesting is this section starts in the years immediately following the ratification of the 1866 treaty. The Creek Nation took specific actions to fulfill its Article 2 treaty obligation to incorporate the Creek Freedmen as citizens of the nation. On October 12, 1867, the Creek Nation adopted a new constitution, vesting the lawmaking power of the nation within two houses, the House of Warriors and the House of Kings. The new constitution authorized each Adowa, a tribal town, to elect a member of the House of Kings and House of Warriors. At the time, 3 African Creek towns, Arkansas colored, Norfolk colored, and Canadian colored, were represented in the legislative body under these constitutional provisions. On October 1st, 1877, a letter addressed to the Legislative Assembly, Principal Chief Ward Coachman recommended that the legislative body take action to recognize the citizenship rights of the Creek freedmen, stating, "Inasmuch as there are freedmen among us whose rights under the Treaty of 1866 have not by some been recognized, and in consequence thereof have been discouraged, are not improving or advancing as they might do, and the treaty relative thereto being so plain that no one can mistake or misunderstand it. I allude particularly to those known as the McGilvery and the McGilbree freedmen, whom we know belong to our own people, were here within our own country when the treaty was made, and have remained among us ever since. I would recommend, if necessary, that some action be had recognizing the rights of all who, under the treaty, are entitled to citizenship and equal rights and privileges with us." And then they continue on. The legislative body subsequently adopted a new law concerning, quote, "doubtful citizenship," end quote, which provided that all persons who have been at any time adopted by the recognized authorities of the Muscogee Nation and all persons of African descent who were made citizens by the Treaty of June 1866 between the Creek Nation and the United States shall hereafter be recognized as citizens of the Muscogee Nation. On October 20th, 1866, the historic Supreme Court of the nation held that, from the above treaty it is clearly shown that there are 3 classes of African descent who are allowed to enjoy the rights of a Creek citizen. First, those lawfully residing in the nation at the time of ratification of said treaty. Second, those who may have resided and may return to this country within 1 year from the certification of the treaty and their descendants. Third, and such other of the same race as may be permitted by the laws of the nation to remain within the limits of the jurisdiction of the nation. It is clear that the historic Creek Nation, including the executive, legislative, and judicial branches of its constitutional government, understood the terms of the 1866 treaty to require citizenship for the Creek freedmen on the same level as by-blood citizens. Okay, so I'm going to skip ahead here a little bit. Let's go to page 21, because this is the next thing I thought was pretty interesting. And I encourage you guys to read the entire decision, because there is a lot of great information in here. These are just the highlights that I read and I thought I'd like to just mention to you guys and read them. Page 21. Let's see, where is that? If you guys have any questions, pop them in the chat. I don't know if I can answer them because I'm not a lawyer, but we can discuss what you ask. Here it is. So this section here is talking about how the Supreme Court is going to rule on this, right? So the 1979 Muscogee Creek Nation Constitution limits citizenship to Muscogee Creek Indians by blood and persons who are lineal descendants of those Muscogee Creek Indians by blood, emphasis added. While it is certainly true that the Muscogee Creek Nation retains the sovereign right to define its own membership, this court has clarified above that those membership requirements must be consistent with any applicable act of the United States Congress in exercising its plenary power over Indian affairs, and the terms of any valid treaty made between the Muscogee Creek Nation and the United States. The 1979 Muscogee Creek Nation Constitution, in its current form, limiting citizenship only to Muscogee Creek Indians by blood and their lineal descendants, stands as a complete barrier to Creek freedmen citizenship and is wholly inconsistent with Article 2 of the Treaty of 1866. As such, the court finds that any reference to, quote, by blood, end quote, citizenship, specifically in the 1979 Muscogee Creek Nation Constitution, but also in the Muscogee Creek Nation Code, or in any associated Muscogee rules, regulations, policies, or procedures, is unlawful and void ab initio. By striking, quote, by blood, end quote, from Article 3, Section 2, the nation is left with the following citizenship provision. Persons eligible for citizenship in the Muscogee Creek Nation shall consist of Mvskoke Creek Indians whose names appear on the final rolls as provided by the Act of April 26, 1906, and persons who are lineal descendants of those Mvskoke Creek Indians whose names appear on the final rolls as provided by the Act of April 26, 1906, except that an enrolled member of another Indian tribe, nation, band, or pueblo shall not be eligible for citizenship in the Mvskoke Creek Nation. With this correction, citizenship is available to any Mvskoke Creek Indians whose names appear on the final rolls as provided by the Act of April 26, 1906, and persons whose lineal descendants of those Mvskoke Creek Indians whose names appear on the final rolls as provided by the Act of April 26, 1906. This court, and that's the Supreme Court, this court interprets Mvskoke Creek Indian, as that term relates to citizenship, to mean any individual who is able to trace their lineage to a Creek by blood or Creek freedman name on the final rolls as provided by the Act of April 26, 1906. Under this interpretation, the nation satisfies its duties to the Creek freedmen under Article 2 of the Treaty of 1866. Okay, so those are the things that I wanted to point out to you guys. They do a good job of explaining the history, and I thought that previous section I pointed out on page 3, talking about how the government was set up right after the 1866 treaty was ratified, was very eye-opening to say, hey, even then that they said that the freedmen should be in the tribe and that they had treaty obligations for that. Now, I've had a lot of citizens, this news actually dropped this morning, I believe, and we posted earlier today on our website about it and on Facebook. And so I've had a lot of citizens call me and ask me, what's going to happen now? What do we do now? So I don't really know for sure what's going to happen. The Supreme Court has made its order and ruling, and now we'll see what the Citizenship Board does. Are they going to issue the citizenship like they've been ordered to? Is there going to be code passed to correct the other parts of the code that mention by blood? Because there's other sections of the code that have that in there. And then the other question that people are asking, and I expect to see probably some court cases about, is the blood quantum in relation to the requirements of code to have a certain blood quantum to run for public office or chief, right? I expect those things to probably be challenged. I don't know how those things will turn out, but this decision has basically established that according to the Mvskoke Creek Nation Supreme Court, the only things in the Constitution that are going to be okay in the future are going to be things that don't contradict the 1866 treaty. So if there's a constitutional amendment or anything like that, as long as it's not violating the conditions of the 1866 treaty, we're okay. So I don't see any questions popping up in the chat, which is good for me because I'm not a lawyer. And I thank you guys for tuning in. Make sure you check out those other 2 legal updates. In the future, I'm going to try to have a guest on that's got some jurisdictional issues with some prosecutions. So I don't want to tell you guys who's yet because I haven't locked it down, but I do think that'll be an interesting lawyered up. And then sometime maybe this week or next week, originally for tonight, I had a live wire that was scheduled with a Muscogee composer that's not one of the ones that we've already interviewed before. It's a person that I wasn't aware of. So when I have when we reschedule that, I'll let you guys know, and that's coming up, but it's going to be soon. And then we are going to shoot tomorrow some footage for the next episode of the gardening show, where we're going to be featuring some citizen businesses and some citizen farms. So look forward to seeing some more episodes of the Gardening Show coming up soon. And if you guys don't have any questions, which I don't see any in the chat, thanks for tuning in, and we'll see you again next time. Mado, hadum, chihichat, lease.